Hi, everyone. Thanks for joining us for our annual marketing compliance regulatory overview. This is by far our best attended event every year, so we're delighted that you're here. We'll begin by reviewing 2025 regulations and trends that impact us today, and then turn our attention to pending regulations and trends we're seeing for 2026. I'm Eric Tejeda, Vice President of Marketing for Possible Now, and our presenters are both from our sister company, Compliance Point, who include Steve Neidick, the Director of Marketing Compliance, and Tony Jarnigan, Marketing Compliance Consultant. Compliance Point provides regulatory compliance expertise at the procedural level, so they operationalize it. Two notes. Number one, we will have a Q&A session at the end of the webinar to answer your specific questions. And secondly, we'll send out a recording of this presentation after the fact. With that, Steve, I'll let you get us started.
All right, Eric, thanks. And thanks for everyone for joining us today. Tony, doesn't seem like we just did this yesterday for last year's recap.
Yeah, if not a few hours ago.
Yeah, so although this year I think there's been a lot more chaos and confusion and concern and uncertainty. And so it's been a wild 2025 as far as marketing compliance is concerned. All right, so overview. We will go over things we noticed in 2025, the recap. We'll go over some numbers and some of the litigation trends we've seen, some of the court rulings, some of the proposed changes or commentary from the FCC. And then we'll go over some key state developments. As far as the 2026 forecast is concerned, we're going to talk a little bit about consent quality, more so the quality of those leads over the quantity of the leads. AI and preemption debate, some of the proposed new FCC rules, and then we'll close it out with a 2026 compliance checklist and answer your questions. Do you want to give this disclosure, Tony?
Yeah, as many lawyers make this legal disclosure, right? Because they're not acting in their legal capacity when they present these things, but it's even more important for us, I think, because we're not lawyers. So don't construe what we say as legal advice or legal counsel, and always consult attorneys on matters of law.
All right, let's get into some of the litigation by the numbers.
Yeah, it's too. You'll see a lot of stats thrown around about TCPA filings, so we thought we'd throw our own around. But actually, these aren't even our own. We got these from somewhere else, right? I've cited all three sources there. And it looks like the sheer number of TCPA lawsuits filed in 2025 was nearly double what the count was in 2024. 53% of class action motions were granted as compared to 37% in 2024. So what does that mean? First, not every TCPA case looks to be a class action. And if a plaintiff does seek class action certification, which has to meet certain fairly rigorous criteria, it doesn't mean they'll be granted the certification by a judge. But so this is an uptick over 2024. And then finally, I thought this was an interesting stat from WebRecon that 44% of the plaintiffs just in the month of December of last year had filed a previous TCPA action. So I thought that was interesting, right? These are recidivists.
Yeah, we're running across some of these professional plaintiffs that have filed 10, 20, 30 lawsuits in the previous year. It's crazy.
Yeah, the serial ones. So why did we see such a jump? I suspect that many of our listeners may know by now or have heard of the South Florida plaintiff firm who's been advertising that they can get you money for text outside the allowable hours of 8 a.m. to 9 p.m., which of course is the federal law. So as I like to say, it's no longer have you been injured in a car accident, it's have you been receiving texts from businesses between the hours of 9 p.m. and 8 a.m. You might be entitled to $500 to $1,500 per text message. These ads are on social media, Instagram, Facebook, even billboards, I believe, in South Florida. This has been going on for over a year now. We started seeing these cases, I think, in late 2024. So in March of last year, the E-commerce Innovation Alliance filed a petition for a declaratory ruling with the FCC, basically saying, wait a minute, if these are consented to texts, are they even telephone solicitations under the definition and subject to the quiet hours restriction. So FCC, can you rule on this and stem these lawsuits? The FCC quickly granted the petition, and I thought there'd be a quick judgment. But as far as I know, we're still waiting on the commission on this. And in the meantime, the ads and lawsuits are continuing.
Yeah, that's a strange one too, because historically, calling time restrictions has always been not low risk, but on the lower side of risk compared to everything else. But
Right.
as all things, we're seeing these professional plaintiffs and regulators point to different areas of these laws, and this is one we hadn't seen that we're starting to see a lot of. So be careful.
Right. Exactly. And finally, and we won't spend a whole lot of time on reassigned numbers database or what's known as R&D here because we're going to talk about it later too, but we continue to hear of a lot of cases where businesses are getting sued because they think they have consent to call or text a certain number, but come to find out it's been reassigned to someone else after, a 45-day disconnect period, and now you don't have consent to call or text that number because it now belongs to someone else. But again, we'll talk more about this later. But suffice it to say, a lot of cases about wrong party contact.
All right, let's give a quick recap on the courts from 2025, Tony.
Yeah, the courts played a huge role last year. We started off the year, as everyone remembers, we started off talking about one-to-one consent. And then on the last business day on the Friday before it was to take effect in January, the 11th Circuit Court of Appeals vacated or struck down the rule, primarily on the basis that the FCC was exceeding its authority. And of course, just as a recap, the rule was going to be that lead forms had to name one seller at a time that would place the call or text, and it would have to be logically and topically related to what the consumer was searching for. Clearly designed to prevent the practice of getting consent for potentially hundreds of sellers identified behind a hyperlink, right? So even though it was struck down, as an FCC rule, we still think the one-to-one spirit is what businesses should be striving for, and we'll talk more about this later too. But what I would consider to be probably the biggest game changer in the courts last year was the Supreme Court decision in the McLaughlin case, right? All of a sudden, U.S. federal district courts, these are the trial level courts, are no longer bound by the FCC's interpretations of the TCPA. Before this, they were bound by what the FCC said the TCPA meant and its rules, declaratory rulings, etc. Even on the circuit or the appellate level, FCC rules and declaratory rulings could be challenged for only, I think, the 60 days, I think it was, but after that time period, they too would be bound. So the biggest impact here is is that now we have few district courts ruling that texts are not calls under the DNC rules. And why? Because the TCPA, initially written in 1991, never anticipated texts, and it hasn't been amended by Congress to include texts. So this is the FCC saying texts are calls. There are other jurisdictions that are concurrently continuing to say that texts are calls for purposes of the law, but obviously this has led to a big split in opinions, and we're currently awaiting a Seventh Circuit opinion where one of the rulings has been appealed. So that'll be very interesting to get that ruling. As soon as the decision was rendered, though, the McLaughlin decision, many legal experts in our industry gave a list of things they thought would be challenged first. And whether text or calls was at the top of, I think, everybody's bingo card list, right? And another was that express written consent, because again, the written part is an FCC construct. But we haven't seen that one challenged yet, to my knowledge.
Yep. Now the FCC, Tony?
Yeah, so what's the FCC been up to? They formally withdrew the one-to-one consent rule after the 11th Circuit struck it down, as we just talked about. They said, we'll just totally withdraw it. We're not going to make any further attempts to challenge the rule or the court's decision. With the new administration and the new FCC chair, Brendan Carr, came the delete initiative. where it was proposed that they would take a comprehensive look at rules that have, that are obsolete, particularly burdensome, or that may even, overlap with FTC rules under the telemarketing sales rule or TSR. Based on comments, they issued one notice of proposed rulemaking around this delete principle that talked about doing away with rules around abandonment. It's real quickly, that's just when you're using a predictive dialer and no agents available within 2 seconds of the consumer answering. And even doing away with the rule that businesses have to maintain their own DNC list. And that was a shocker to a lot of people, but they backed off of that one in their next iteration of their proposed rule.
I think they realized that would have been a bad decision.
Well, I never thought that those would have been that impactful in the first place, because the FTC has the same rules under the TSR, right?
Exactly. Exactly.
And that's just my personal opinion. But now, so, next, some consent revocation rules went into effect, including that businesses have to accept a revocation by any reasonable method, including in relation to text, whatever someone may text back to you, regardless of the word that you ask them to use in your opt-out instructions, right? We've talked about the middle finger emoji. We've talked about expletives, sorry. But this is, this is apparently now being looked at too in the context of the delete initiative to determine if maybe it's too onerous, or businesses, and maybe, they should be allowed to determine the method of opt-outs. The one rule that is not in flux, though, is that time frame rule, that opt-outs have to be honored as soon as reasonable. And notice we've put that in italics. That's very important. We're going to talk more about that later, but not to exceed 10 business days. And then finally, what's come to be known as the revoke all rule. What is that? It's the notion that, when a consumer revokes consent to one type of text from a business, that without further clarification, the revocation would have to apply globally to all future calls and texts from that seller across all channels and campaigns. So that rule it was delayed once, then it was delayed again, and now until what, January of next year. But it too is being looked at on a parallel track, right, in the context of the final notice of proposed rulemaking, to see if there's some other solution than an opt-out having to. What?
And isn't the concern here, Ty? Sorry, I didn't mean to interrupt your train of thought there, but some of the concern here is even on the business friendly side, because you're potentially running into informational text messages or appointment reminders or calls from your HVAC person saying, I'm going to be there between 1 and 3, that if someone revokes all from one, they might not get those types of messages anymore.
Exactly right. Yeah, you're absolutely right. I mean, so this is, particularly impactful to, those in the healthcare space and, banking space. I'm proud to say that actually one of my clients, I think, was probably instrumental in getting that delayed the first time, that's in the healthcare space. So.
Perfect. All right, I'll go over the states here. One of the growing trends we're seeing across states is expanded private rights of action and plaintiffs testing the edges of consent-based compliance. So case in point, we talked about it earlier, is the chaos in the space Texas caused. I mean, there was so many people going to register in Texas that hadn't registered before, that the state actually had to pause everything, and they were backed up months from what I've heard. So Texas, exactly. It was Senate Bill 140, which became effective in September of 2025. So it's a big deal because it brings telemarketing practices squarely into the Texas Deceptive Trade Practices Act, or the DTPA. So this law provides lawsuits, not just AG enforcement, with statutory penalties of up to $5,000 per violation. And then under the DTPA, that can escalate quickly if the conduct is deemed knowing or intentional. So you can treble those. Back in November of last year, there was a settlement provided a little bit of clarity. Some consent-based opt-in text messages do not, by themselves, trigger registration requirements with the Texas Secretary of State or the Attorney General, but only if you're only performing texting campaigns. But here's the unresolved issue and the risk area for compliance teams. That settlement did not eliminate the private right of action.
Exactly.
So, yeah, so even if a company believes it has valid consent and is properly registered, plaintiffs may still argue that the content, the timing, or the opt-out handling of messages violated the DTPA. So the takeaway here is text is no longer just about registration and consent. It's about whether every element of the consumer interaction can withstand that DTPA scrutiny. Tony, anything you want to add on that?
No, I think you covered it very well. Exactly
And
right.
then- All right, perfect. Now we'll move into Washington. So Washington takes us one step further. In Brown versus Old Navy, the Washington Supreme Court ruled that any misleading aspect of commercial email is actionable, even if that email is not outright false. So that's kind of new to us. It's always been email compliance or risk is usually always been on the lower side of things, right? And we hadn't seen too many enforcement actions, but this brings in new elements here. So, and when I say deceptive subject lines or things like that, I mean, it includes things like saying today only about a sale when the promotion actually lasts multiple days. So you just want to be cognizant and careful of what your subject lines are saying and not put misleading things. Don't make false promises. Don't create a false sense of urgency, that kind of thing. So the court made it clear that deception does not need to be material, say in the traditional sense, and consumers do not need to show actual reliance or damages. So as a result, Washington's Commercial Electronic Mail Act, or SEMA, has effectively become the TCPA of email, right? So this ruling triggered a wave of class action lawsuits against brands like Nike, Macy's, and Southwest Airlines, often focused just on marketing language, urgency cues, and promotional framing. So in response to that litigation, what we're expecting maybe in 2026 is in response to that litigation, Washington lawmakers have proposed a bill that would raise the bar for plaintiffs. So the proposal would require proof of material misrepresentation and actual harm, which would significantly narrow liability. But however, until and unless that bill passes, Washington still remains one of the most aggressive states for email marketing exposure in the country. So pay attention to that.
Right.
Anything to add there, Tony?
Well, yeah, I was just going to say, sort of, make a note about, the intersection of this with canned spam, right? So, a lot of people think about this and, look at this and think, well, wait a minute, isn't canned spam preemptive? I mean, why are we even talking about this? I mean, preemptive meaning that, states can impose additional email requirements. And the answer is yes, it is preemptive, generally considered to be a preemptive law. So no, states can't impose more onerous requirements, but there's also this savings clause, meaning that states can prohibit false or deceptive statements in commercial messages. So this is just about being truthful. And by the way, I'd also point out that, the lower court, this is a Washington State Supreme Court decision, right? So the lower courts, trial level, appellate level, they both had ruled against the plaintiff, saying that, generally your misleading part has to be about the promotional nature of the email, right? So in other words, your subject line would have to be something like make you think it's informational or whatever, and then you open it up, and then it's not until you open it up you find out that it's promotional in nature. But no, they're saying that anything that's misleading is actionable under the law. That's why we've got, the legislature has proposed this new bill just this month. So yeah. And by the way, I'm sorry, I was going to add too, if you're complying with canned spam to the letter, then you should be fine here too. It's just that what makes this worse is that now that it's a private right of action, right? But what I always like to tell clients is that, if you're wondering what might be, deceptive or misleading, apply a two-pronged test. All statements should be truthful and not misleading, right? It has to be both, because a truthful statement can be misleading if it omits material facts. But so you got to make sure it's truthful and not misleading, and don't use those false senses of urgency.
Yeah, great point. I mean, the regulators and the courts are definitely shifting focus to how messages are framed, how urgency is communicated, and whether consumers could be misled. So even technically or indirectly. So for compliance teams, it means tighter review of message content, the subject lines, opt-out functionality, your documentation. I mean, especially in states like Texas and Washington, where private plaintiffs are driving the enforcement.
Right.
All right, let's get into some consent quality over quantity. So as we look ahead into 2026, the dominant theme across regulators, courts, and plaintiffs' attorneys, it's pretty simple. Consent quality matters more than consent volume. I mean, we've all seen those huge volumes of purchase leads and things like that. Well, you may not know if those were valid or quality leads or not. So as Tony mentioned earlier, in honoring the spirit of one-to-one consent, regulators are increasingly focused on not just on whether valid consent exists, but whether it reflects the spirit of one-to-one consent, right? So it means consumers understood who would contact them, how and why, and that the message they received aligns with that expectation. So we're seeing less tolerance around consent language and more scrutiny of whether the consumer experience feels transparent or not. So, and then we get into the broader inherited consent leagues. Those are getting harder to defend, especially challenging for companies relying on broad shared or inherited consent, such as purchased or syndicated leads. So even when contracts say consent transfers, courts and regulators are asking, did the consumer actually expect to hear from this specific brand? I mean,
Right.
The perfect example you gave, Tony, those marketing partner links with thousands of different companies listed. It's confusing and not clear to the customer that's going to get those calls.
Right. And I was going to say, add here real quickly too, Steve, you know that even before the one-to-one consent rule was to take effect, I was covering cases for our monthly compliance newsletter where, it fit this exact fact pattern, right? The plaintiff sued and said, you texted my number that's on a do not call list, you didn't have consent. And the business says, well, you did have consent because you filled out this lead form. And then, they look at it and say, this doesn't mean any semblance of clear and conspicuous whatsoever. So no, you did not have consent to text or call this person.
Or even the topically and logically related things. So I can give you a real world scenario that that we've seen, and it's a perfect example. So we're reviewing third-party lead gen forms from one of our clients. One of the URLs we reviewed that they were purchasing leads from was a third-party site that was just asking prospects to answer which M&M color was their favorite. And after that was asking that question after they've put in all their contact information, there are no disclosures, there's no branding, there's no products, just what color M&M is your favorite. But unfortunately, little did the consumer know in those instances that their information was being sold as contactable leads and called upon for marketing purposes. So those consumers were obviously not expecting to receive telemarketing calls selling them products or services based on their favorite color of M&M. So in 2026, simply pointing to upstream disclosures or lead contracts will not be enough. Companies really need to show a direct, defensible link between the consumer's action and the outreach, which kind of brings us into clear and conspicuous brand identification, right? So another major focus is going to be on that brand identification. The consumers have to be able to immediately recognize who's contacting them, right? So not buried in fine print, not implied, not through partner links like we just talked about, and not revealed only after that engagement. So we're seeing enforcement and litigation where brand ambiguity alone is alleged to invalidate consent, even when the opt-in itself was otherwise valid. We can get into auditable operational items here. So finally, compliance can't live, and we always stress this when we're on calls with our clients, is compliance can't only live in policies or memos, right? It has to be operational and auditable. That means being able to produce records showing when consent was captured, what the consumer saw. So what did that URL look like on that date and time that consumer entered their information? How it was stored and how opt-outs are honored in real time. So again, the question is not going to be, do we have consent? It's going to be, can you prove system by system, message by message, that consent was valid? So bottom line, growth strategies built on volume first consent models are very high risk, right? While intentional, brand specific, well documented consent, it's actually becoming a competitive advantage in creating a better defendable position. Anything you want to add there, Tony?
No, great job.
All right, AI, I'm sure it's in everybody's mind. We're getting all sorts of questions about AI, and a lot of companies starting to figure out how can we take advantage of this and what can we use it for. So as we head into 2026, one of the fastest emerging risk areas in telemarketing compliance is obviously the use of AI and its regulatory uncertainty, which comes with consent and transparency risks, right? AI is increasingly being used across the marketing life cycle, from lead scoring and dialing optimization to message personalization and even conversational bots. So from a compliance perspective, the concern really isn't the technology itself. It's whether AI-driven decisions change the nature of consumer consent. So I can give you an example. If AI determines who gets contacted, when they're contacted, or how messages are phrased, regulators might ask whether the consumer actually consented to that type of interaction. So remember, the regulated use of artificial voice, it was really nothing new. I mean, if you go back and look at the pre-recorded message rules that apply, you'll see in that verbiage that it actually says pre-recorded message or artificial voice. So again, it's not new. We have to follow those pre-recorded message requirements if you're using AI to push out calls or recorded voices. So again, it's a growing transparency expectations, particularly around whether consumers understand that they're interacting with automated or AI systems. So with that said, there are some federal preemption efforts. We're seeing renewed federal efforts to preempt the state AI laws in the name of less complexity and difficulty in complying, because we all know, similar to telemarketing laws, right? It's when each state has their own rules, and then you have federal rules, and one doesn't preempt the other, things can get very complex. So the goal is to, from the federal perspective, is to avoid a 50-state patchwork of AI requirements. But if now preemption remains uncertain, it's being politically contested. So for compliance team, it creates a kind of a holding pattern, right? So we can't rely on federal preemption to simplify our obligations in the near term. And then at the state level exemption, in the absence of clear federal rules, states are moving forward on their own. So some states are experimenting with AI-specific disclosure requirements, accountability standards, also expanded private rights action, right? So the challenge is that these laws are not uniform definitions of AI, automated decision-making, consumer harm. It can really vary widely. So it means a practice that is compliant in one state could be legally risky in another. So what does this all mean for 2026? The key takeaways, obviously, compliance programs can't necessarily wait for regulatory clarity. You should always take the most conservative approach. I mean, similar to the texting, right? How we see some courts saying texts are calls are texts, and then other courts saying it's not. I always advise to go with the more restrictive or conservative approach here, just to keep yourself out of hot water. So
Exactly right.
And
we've already seen some clients. I'm sorry,
Sorry,
Steve, I was gonna say, we've already seen some clients that are doing all this, right? They're making sure they, even though they say artificial voice in their consent language, they're being extra cautious and including AI in their consent language, and then they're disclosing it on calls if it's applicable. So, they sort of see the writing on the wall and just going ahead and, getting sort of ahead of that.
Yeah, exactly. I mean, I think what we're seeing now is, and really, organizations need to really just inventory where is AI used in telemarketing workflows, understand how it affects consent and disclosures, and just build controls that can adapt as standards evolve. So we really just have to understand how it's going to impact consumers and can you govern it correctly. So the AI debate isn't speculative anymore. I mean, it's becoming an operational compliance issue that telemarketing programs need to address now rather than later.
Yeah.
All right, let's get into some of the forecasting for caller identity and foreign origin call transparency. You know, caller identity is becoming a frontline compliance issue. It's really not just a carrier concern any longer. And as part of the FCC's final notice of proposed rulemaking, the commission is looking at ways to strengthen trust in caller ID information, especially for calls that receive A-level stir shaken attestations. The idea is really simple. If a call is fully authenticated, consumers should receive verified, consistent identity information, not just the phone number. So one proposal under the consideration would require carriers to transmit verified caller identity data, such as the caller name, whenever a call receives that A-level attestation. So it really means businesses can no longer be able to rely on inconsistent or truncated caller ID records. So for the compliance teams, kind of raises questions about how brand names are registered, standardized, and maintained across vendors and carriers. And then there's also the expanded use of rich call data. So the FCC is seeking comment on expanding the use of rich call data, or RCD, particularly on IP networks. So RCD allows verified information like the business name, logo, and call reason to be displayed directly on the consumer's device. Again, we're really focused on cell phones here. So while this can improve answer rates and consumer trust, it also increases the risk that the data is inaccurate, if it's outdated, or if it's misleading. So branding errors could soon be treated as compliance failures, really, not just marketing mistakes. Another key focus is ensuring the accuracy and integrity of the caller ID information presented to consumers, right? This means stronger expectations around data governance, who controls caller identity data, how is it updated, and how are discrepancies corrected. I mean, this is definitely one item that companies, if they hadn't been focused on monitoring enforcement for caller ID, that is definitely one thing they should be doing. Regulators are likely to ask not just whether identity data exists, but whether it's reliable and it's audible. And then we'll get into some foreign origin call transparency. So they're also proposing some rules to address foreign origin calls. This includes requirements to clearly inform consumers when a call originates outside the U.S., even if it uses a U.S. phone number, you need to clarify that it's foreign. Also considering prohibitions on spoofing U.S. telephone numbers for calls that originate abroad. Obviously, it's designed to combat fraud, but that has real implications for legitimate businesses using offshore call centers or international routing. So what does this all mean for 2026? I mean, the big takeaway is the caller identity is no longer just about avoiding spoofing. It's about affirmative transparency. Telemarketing compliance programs need tighter coordination between legal and compliance and IT and telecom teams to ensure that the identity data is accurate, verified, and that it's consistently presented. Tony, anything you want to add there?
Not overall. I mean, this is good. I was just going to say too that around caller ID, right, on the state level, I think it's important to point out that more states are passing laws around caller ID requirements. I haven't really heard anybody else mention this, but it seems to me those are particularly where you say, well, okay, well, this is what's the big deal here? Same requirements on the federal level under the Truth and Caller ID Act, but not necessarily. In the Truth and Caller ID Act on the federal level, basically you're not supposed to manipulate caller ID for the intent to defraud, right? So a lot of these states are now using language, it seems to me, that doesn't necessarily have the intention to defraud. It's just about misleading. So what does this mean for local presence caller ID? If a business doesn't have a storefront in a state, right, but they're trying to call somebody in that state and they're using local presence caller ID to make it look like that it's somebody local, is that misleading? It depends on how you interpret some of these newer statutes. So I just think, to keep an eye on that. Again, I haven't heard anybody else talk about this, but it just seems to me that the way that some of these statutes are written on caller ID now, that, that local presence caller ID, the act or activity of using local presence caller ID, could be in scope for those.
Yeah, and we may see, I mean, South Carolina has that rule, right? And we may see other states adopt it, but South Carolina says that, you can't display a local presence area code for South Carolina area code when you're placing calls into the state unless you have a physical location in the state. Right.
No,
But I agree with the deceptive or misleading. And we all know that, initially, I forget how many years ago that this came out, but your thought process is a local number. If someone's calling me 404 area code local, I might be more likely to answer it than otherwise.
Right.
But the difference about it not being deceptive is, yes, that they may be in California and they're calling me in Georgia, but as long as the number displayed, I can call them and reach them back. That's where some of it's not really deceptive at that point. It's so we'll see where those rules go. But yeah, there could be some changes coming down caller ID. All right, let's get into Tony, you want to go over the compliance summary checklist?
Absolutely. So these first two bullets are both about consent, right? So I'll sort of talk about them together. Like we said earlier, ensure you have valid, provable consent. And ensure you have records, right? No record didn't happen. Monitor third-party lead flow. This is where we were talking earlier about the spirit of one-to-one consent. We can't stress this enough. Ensure a third-party lead generator either matches you with the consumer based on how how the consumer answers questions. For example, in insurance or home warranty space, as examples, a lot of these lead generators will ask a number of discovery type questions, and then they'll match you. And then the consumer agrees to your own consent language, right? Or make sure that the lead generator specifically identifies you and your business, your brand in their clear and conspicuous consent language without having to click away. So, ask to see your vendor URLs and lead forms. I've heard this recently from clients that say, well, I say, can you get me what lead generators are you using? Can you get me URLs? And they say, no, I can't. We just can't get we've asked for those before. We can't get those because, we do that for clients. We review those for clients, right? We review those lead flows to make sure that our clients are getting valid TCPA consent. But if they tell you they can't provide you a list of URLs that they use, move on. If they're only identifying you behind a hyperlink, move on. There are some lead generators that do things the right way, and that's obviously the ones that we would recommend. And next,
Tony, let me just start. I mean, it seems like harsh what you're saying, right? But get rid of them or move on, but really that's what you need to do if you want to keep yourself in a safe place, because again, without any records or evidence, you have no defendable position. So although harsh words seems harsh, you should probably take a good look at it.
Yeah. And if there's nothing else that listeners take away from this webinar, and we touched on this earlier too, honor opt-outs as soon as possible. Earlier, I noted that, as soon as reasonable was in italics, and the as soon as reasonable, but not longer than 10 business days rule. And, it is, that's, to me, that line, the as soon as reasonable or possible is more important than the 10 days. We've seen DNC policies that say, we'll implement a DNC or do not text request in 10 days. No, we've also seen companies get sued for texts sent 1, 2, or 3, or 4 days later. And the defendant business will move for a motion to dismiss saying, my client did this within 10 days, but guess what happens? The courts deny the motion to dismiss, saying what's reasonable is a question to be answered at trial. It's not during the pleading stage of the case. So the business must decide, do I continue to pay to litigate this to find out what my reasonable time frame may have been for my business practice and my capabilities, or do I just go ahead and settle and get it over with? What do you think
Yeah,
they're
and
choosing?
the other thing with that is just you're opening up yourself. We always mention we're trying to reduce consumer complaints because consumer complaints is what leads to regulator requests, right? So I'm not quite sure why you'd want to call someone 2 days after they told you don't call me ever again or don't text me, and then you're doing it 2 days later, 4 days later, 6 days later. Those are the consumers that will tend to complain,
Right.
and you just need to honor their wishes for sure.
Yeah, but these companies are opting to just to go ahead and settle. So, even though it may have been determined that their time frame may have been reasonable for their business and practices, they're just not going to continue to. It's going to cost them more money to litigate to find out what that
Right.
is.
Yep.
So
Yep.
just consider it an immediate kind of thing, right? Strive towards making it an immediate a thing. So reassigned numbers database, R&D, we talked about this earlier too, right? Leverage that database, especially if it's been a while since you've contacted a consumer or had any contact with your customer, right? You need to ping the database with the number and the last day, you had consent, and then it will tell you, yes, the number has been permanently disconnected since the consent date, or no, it hasn't, which means it's still good to call. Or you might get there's a third option, you might get no data, which means it can't determine the status. And then you should err on the side of caution there and treat these, as higher risk. So basically it helps you decide, can I proceed and then call, or should I definitely not call, or the no data, I need to do additional investigation, right? And then finally, keep your eye on that Washington bill that we talked about. Even before it passes or in the event that it doesn't pass, you should make sure you review your business's subject lines or the whole email for that matter, right? Make sure any statements always meet that two-pronged test that I talked about, that they be truthful and not misleading. So I think that wraps that up. Anything you want to add there, Steve?
No, I think you covered it well there. Again, and just the R&D. I mean, we mentioned domain, so it's proposed in Missouri, could become a trend, and then, yeah, just be careful with the subject lines. Well, now we will turn it back over to Eric.
Steve and Tony, thanks for your insights today. If anybody has any questions, please send those to us in the chat pane. And as a reminder, we will send you the webinar recording for your reference and to share with others in your organization as you see fit. I'll also quickly point out, while we're waiting for those questions to come in, that if you want to go deeper in marketing compliance, data privacy, or information security, Compliance Point is having their annual Compliance Point Exchange Summit in just a few weeks from March 9th to 11th in Orlando. So would love to have you join us for that if you care to, but you'd need to act quickly because it's coming right up. Also, tomorrow, Possible Now is actually launching our most significant DNC solution release ever. It's a completely updated UI and has new compliance capabilities to better manage all of today's complex compliance requirements. So there's a lot going on. Certainly feel free to reach out if you have any questions. All right, let's jump into the questions. So question number one is, should companies be reviewing email subject lines nationwide using Washington standards, even if they don't operate there?
Tony, you want to take this one?
Yeah, for sure. That's an interesting question. That's right. It's one that we've heard before, actually. Again, we think Washington and California are the higher risk areas, certainly, because of the private rights of action under their unfair and deceptive acts and practices laws. Excuse me. But the requirement that your subject lines and headers not be misleading, that's a requirement under the federal CAN-SPAM law too, right? So, yeah, I'd recommend reviewing subject lines and headers across the board. Not that false senses of urgency are necessarily on the FTC's radar, but still, if you're one of those companies that always has the same sale or the same promotion and it's always going to end today or midnight, this is probably not a good look from a brand perspective. But yeah, review subject lines, headers, and make sure your subject line captures the true purpose and commercial nature of the email as required under CAN-SPAM. if it is commercial in nature, of course, and don't mislead, and
Agreed.
make sure they meet the two-pronged test, right, that we called it earlier.
Yeah, agreed. I mean, it doesn't hurt to be transparent, and it doesn't help usually. The example I always give is the home alarm company sending out an email campaign that says there's been 4 break-ins in your neighborhood, and it's just things like that. You just want to be truthful. I know you want to get
Right.
your emails open, but try to be as transparent as possible.
Right. One that I saw in a previous role was, "We've been trying to reach you." Sounds pretty ominous, right? And then you open it up and come to find, I mean, they had been trying to reach them, but it was because they wanted to see if you wanted to add on to your current, your current package.
Exactly. Okay.
All right, great. Next question is about consent. How do we demonstrate the spirit of one-to-one consent to a court without a formal rule?
I can take that one too. So, I mean, it's another good question. I think we alluded to it somewhat earlier, right? Ensure you're using lead generators that either match you based on a consumer's answers to questions or on a website, and then let them affirmatively click to agree to hear from your business based on your own consent language. That's option number 1. Or I'd say option number 2 is ensure you're identified in the consent language of the lead generator, ensuring that it's valid TCPA consent language. So in a nutshell, I'd say ensure that consumers expect to hear from your organization. Don't make it a surprise, right? This is all about managing consumer expectations, right? And we always say if you're doing that and managing consumer expectations, you're probably at least 90% of the way to compliance. But we shouldn't lose sight here either of the fact that another part of all this is the clear and conspicuous standard, right? And the FTC has provided some guidance here relative to the TSR. Basically, the disclosure should stand out and be unavoidable. It's generally recognized that disclosure language should appear above the call to action button. We see it often below, but it should be above the call to action button. So like your I agree or submit button, so that it helps with the unavoidability standard, right? And this is particularly important too for mobile devices, where if the language was below the call to action button, the consumer may not ever see the consent language because it didn't scroll far enough. So, and it should be at least the same font size, same contrast with background as surrounding language. If you want to make it stand out in terms of size and contrast, even better. But you certainly shouldn't make it any smaller or harder to read than surrounding text.
And then the other thing too, and I don't know if you were going to address this, but we always advise against consent language that says you're consenting to receive calls from our marketing partners. That's the link, and you click on that link, and I've seen ones literally where 5,000 different company names have come up, all from different kinds of industries.
Right.
So those are the kinds of things you definitely want to avoid as well.
Yeah, that would be a little
Like we talked about.
Yeah. All right, great. So the next question, do you recommend treating AI disclosures similarly to auto dialer disclosures even before rules are finalized?
Yeah, I'll take that one. It doesn't hurt, and it almost lends itself to the previous question about transparency is not such a bad thing, right? So if you are having an AI bot that's making a call recording, just state this is Steve, your AI chatbot, or this is Steve, your AI customer service rep, or whatever. But I think it does help, and I think that's the direction everyone will be going in with these laws. Tony, unless you feel differently, but I think it's best just to get used to it and do it now. Be straight up. And again, you don't want to make someone think they're speaking with a human, which I think most of us know if we are or not. But you don't want to trick someone and think you're speaking with a human when it's actually an AI bot. So
right.
Yeah, I would disclose that.
Good. All right. And this is the last one we've got queued up right now. So if you've got any other questions, now's the time to put them in there. For organizations that feel like they're already compliant, where do you see the biggest surprise risks right now?
I'll take that one, Tony, too, just because I've been doing this such a long time. 23 years, 22 years this month, I think. But I can't tell you how many times we've started an engagement with someone that said, we are completely buttoned up, we know we're compliant, we just want someone to come in and check under the hood just to give us their blessing. We have never gone in to do an assessment. where someone has been 100% compliant. So there are going to be areas. So I think that's the biggest surprise to our clients that we go on site with is there are areas that they need to comply with that they may not have even considered. Take a look at your telemarketer registration, see where you're registered, where you're not. If you're not, why not? Do you have an exemption? Look at your lead sources. Where are they coming from? Are they coming from partners, third-party lead gens? Do they have the right disclosures? Just make sure you have a good idea of what all of your departments, marketing department, sales, what they're doing, how many times they're calling consumers, and monitor and enforce. You got to make sure if you have guidelines in place, the guidelines are useless unless you're monitoring and enforcing those to ensure what's happening really is happening. So I would say the biggest surprise risk is you're probably not as compliant as you think you are. And it is a good idea to do a deep dive just to uncover all of the different areas of compliance.
Right.
And
But at the very least,
yeah.
yeah, I was gonna say at the very least, again, what I said a few minutes ago, right? Manage consumer expectations. Don't make things a surprise, and make sure you got a record, right? You got record keeping.
And let's
Once again,
avoid,
no-
try to avoid those consumer complaints because that's what
Right.
leads to the regulatory investigations.
Right. So no record. It didn't happen.
Yep.
All right, great. Well, that looks like all of our questions. So Steve and Tony, thanks for your sharing your wealth of knowledge today. And to all of our participants, we so appreciate you being here, and we will see you at the next one.
Thanks,
Have a
everyone.
great day.
Thank you. Thank you. Take care.